guys, good morning. What's up? Can everybody see me, hear me? Am I live? It says I have one person watching me, but I see people in chat. Hang on a minute, guys. Okay, Robert Bardo. We were in the middle of JOA, which is Judgment of Acquittal. Is that what it's called? His stupid attorney was getting up, and he already got up and said they didn't meet their burden of proof, that it was premeditated. I think the argument is not that he did it, but that he didn't premeditate it. Did I say that right? Premeditated? I think I said that right. Anyway. And so we had to quit in the middle of Marsha's judgment against the JOA, argument against the JOA, to go to Brian Walsh's trial. So we're going to be picking up in the middle of her argument. And let's read Judy's trivia. Bardo reportedly had a troubled childhood. Oh, boo-hoo. They always have a troubled childhood. That doesn't mean that they had to go kill someone. Bardo reportedly had a troubled childhood, being abused by one of his siblings. He was placed in foster care after he threatened to unalive himself. Bardo's family had a history of mental illness. At 15, Bardo was institutionalized for a month to treat mental health problems. During his trial, he claimed a song was an influence in the Red Room, and the song was played with him lip-syncing the lyrics. Alrighty then. What song was it? Well, I guess we'll find out. Good. Jen, if you really need to, what's with the name change, Jennifer? There's a story behind that. I need to know it. Good morning, Jen. Good morning, Judy. Good morning, Wiggles. Hey, Marty. Oh, that's right. He was obsessed with you too. Travis is... The doctor agreed with my assessment. She's actually a nurse practitioner, so that explains a lot. That he possibly has a pinched nerve in his neck, so they're sending him for a scan of his neck. And he has high blood pressure. And I took it this morning and it was high. He's on a blood pressure medication now. Spike has a bad back, just like his mom. He's on 2 medications. He's on gabapentin for nerve pain and a doggy anti-inflammatory medication. Okay. Okay. I was trying to find a clip of him saying, "Kill me," into the mic at the Karen Reed trial. And I found it, but like people made shorts of it with like stickers and words, and so I couldn't like clean it up so that I could use it. So I just said, forget it. And with everything else going on, I didn't feel creative. So it's just like, yeah, we don't even have our Christmas tree up yet. I was gonna get up and this was gonna be a new day, and I just can't do it, y'all. I'm sorry. Okay, Wiggles. What in the heck is this? Why'd you say bye, Marty? I'm not going anywhere. I just might break into tears every once in a while.
I rang the doorbell again. No answer. Then she came. During those events, he is waiting. If all we found was at that very moment when he came back to ring her buzzer again.
You guys are the only thing that are bringing me any joy right now. Where'd my toilet paper go?
That was the only period of watchful waiting. That would be sufficient. I think we have more, but if all the court would find would be those moments after he rang her doorbell for the second visit, that would be sufficient. As he waited for her to approach, the defendant described what she wore, the robe in which she was found. And significantly, he stated, her head was looking down. A very specific description that holds a great deal of meaning. If we consider that statement even for a moment, the oddity fairly slaps you in the face. Why in the world would her head be looking down when she, a nearsighted person, wearing no glasses or contacts, is approaching a glass door just a half hour after having contacted this defendant who, at the very least, made her uneasy, and most likely made her much more uncomfortable than that, by his first visit? We have no reason to doubt this detail recounted by the defendant, and I have no doubt that he would not have included it if he had realized what it meant. Because what it means, in the context of all the evidence, is that the defendant was not visible to Rebecca as she came to the door the second time. And that is what the photographs taken with Detective Bolin standing behind the bush from Rebecca's perspective inside the apartment are offered to illustrate. The ease with which the ambush was accomplished by the defendant. Nothing fancy, but as we can tragically see, very effective. So when her buzzer rang the second time, she looked down the hall. She saw no one at the front door. She concluded a messenger had left a script for her, as has happened many, many times in the past. And as she approached the front door, her head was indeed looking down to see the script she assumed was there on the front porch. The position Rebecca was found in, with her legs propping open the door and the blood spatters on the porch, the door, and the wall, revealed that the door was open from anywhere from 45 to 60 degrees, but a minimum of 45 degrees. And Rebecca was actually standing out on the porch at the time the shot was fired. This could never have occurred, Your Honor, if she had seen the defendant or indeed any tall stranger at the door. Had the defendant been standing visibly at the door, there is no way anyone could reasonably believe that dressed in only a robe, with no glasses, no contacts, that she would open the door and actually step out to confront the strange man who left her uneasy just a half an hour earlier. To believe that she would do such a thing absolutely snaps the bands of credibility. Once she opened the door and stepped out, the defendant had her in perfect position, vulnerable, unshielded, and unsuspecting. He stepped up quickly onto the porch, grabbing her right arm to prevent her from closing the door, and fired directly into her heart at point-blank range. And that is why Lynn Marta heard no voices before the shot was fired, and why a mere split second elapsed between the time Rebecca passed her doorway before the shot was fired. Thus, when the evidence is pieced together and viewed logically as a whole, what emerges is the very picture of a stalker who hunts his prey, luring his victim into a lethal trap. That failed first visit, Your Honor, in no way can be said to show the defendant abandoned his long-formulated plan for murder. Rather, as noted by the Supreme Court in People v. Byrd, it actually demonstrates that the ultimate act was not hasty, but was instead a considered, deliberate act which was the product of an unbroken watch. After his first attempt, therefore, was thwarted, this defendant purposefully, with cold calculation and premeditated desire, lured Rebecca out of her home, out onto that porch by means of deception, as he waited watchfully until she was fully out the door, when he sprang out, taking her by surprise and restraining her from attempting to flee, brutally took her life with that fatal shot. This case, therefore, describes, in my opinion, Your Honor, the very paradigm of lying in wait under even the most strict interpretation of the elements. Therefore, the people respectfully submit that the case has easily been proven beyond a reasonable doubt and request that the motion pursuant to Penal Code Section 1118 be denied.
Thank you, Ms. Clark. Mr. Glenn, wish to reply?
Yes. The whole problem here is that to reach that conclusion, the court, trier of fact, has to engage in a tremendous amount of inference and speculation to reach that conclusion. The fact that it is claimed that he devised a plan, there's no evidence whatsoever that there was a plan to do as the DA has theorized. None whatsoever. Not in the letters, not in the statements to any of the witnesses, not anywhere is there any evidence of that specific of a plan. The fact that Robert Bardo, was not visible to Rebecca Schaeffer, again, there's no evidence to that. There is speculation and inferences that are being raised, but if we are to believe her boyfriend and her neighbor, she was more cautious than that and would not approach the door. But there is no evidence that she didn't see anyone. And that's the type of thing that bothers me here with this argument. There are a number of these type of conclusionary speculations that you're being asked to draw, and I don't believe that they're reasonable. That Rebecca Schaeffer thought Robert Bardo was a messenger, where do we ride from that conclusion, draw that conclusion? What evidence is there that she thought Robert Bardo was a messenger? None whatsoever. We know that he was there the first time. We know that because the best friend corroborates what Robert wrote in the letter, which is he detailed exactly what Rebecca Schaeffer was wearing. So we have proof that, at least as to that aspect, what he said is true. If Rebecca Schaeffer was careful, she would have seen Robert standing at the door. If she were extremely cautious, I don't think she would open the door not seeing somebody there. But again, that's speculation, that's an inference. I'm asking the court not to draw those type of unreasonable inferences, but decide this issue based on the facts and the facts alone. The fact that she was claimed to be uneasy, we don't know that. That Robert Bardo supposedly grabbed Rebecca Schaeffer's arm. That has not been established. An inference has been raised because there was some bruising, but the bruising could have been as old as 4 hours. That Robert Bardo engaged in a deception and restrained her and lured her. All of these are inferences, are speculation, are guesswork based on some evidence. You talk about the letter. The letter as being reliable in some things that it states, but unreliable and self-serving on the other. I don't believe that the prosecution can pick and choose. We know that when they introduce a letter, such as they have in this case, People's 45, I believe it is, they're usually bound by the exculpatory portions when there's an absence of other contradicting evidence. There is no reason to think or believe that Robert Bardo knew that when he mailed these letters out, that the police were going to be alerted by the sheriff's people in the jail, that then a search warrant was going to be obtained and executed at the residence of Robert Cleves. There's no evidence to believe that, and of course we've stipulated that the court can't consider the file and the documents and the testimony presented at the hearing on that issue, because at that hearing it was discussed the exact level of knowledge that inmates have. And on that letter, the envelope that Ms. Clark referred the court to.
Let me interrupt. I said I wouldn't interrupt, but nobody has ever furnished me with the transcripts of those hearings. I asked for them yesterday. I still don't have them. I will accept stipulations as to what they say for the purpose of this hearing. But to ask me to refer to something that has repeatedly not been furnished to me, and I'm not blaming anybody because I don't want to disentangle that web, but I haven't read them.
Okay. Well, the court is aware, and the stipulation did include the documents, pleadings, and papers that were in file, that are in your file on that issue. So that will give...
Mr. Galindo, you could include in a stipulation that you want me to consider the 25th page of the Koran, but if I don't have it, I can't do it.
Fair enough, Your Honor.
All right.
In any event, if you look at the back of that letter, which Ms. Clark directed to your attention, there is a reference of please mail after inspection. From that, you're being asked to infer that he knew they were going to review it for content, which there's no evidence at all that that was in fact the case, at all. The inference, if you're going to be asked to draw an inference, I would ask you to draw the inference that all letters have to be inspected before they get mailed out, because the representatives at the Sheriff's Department check for contraband and a host of other things in reference to those letters. But there is no evidence at all to draw the inference that Mr. Bardo knew that series of events were going to occur. Prior to that time, there's no evidence to show that any of his letters were obtained or restricted by him or somehow brought to his attention that they were going to be used in court. And the fact remains that there was a hearing wherein the district attorney sought to introduce those letters, which we opposed at the time. So that from that you can draw an inference, I think. But the bottom line is that all of these speculations and inferences, I think, do not rise to the level of proof beyond a reasonable doubt. And that's what this hearing was all about, too, because feelings of hatred and intent to kill and everything in between. But there is no evidence to state that those feelings did not vacillate between the two extremes. That is the problem we have, and that is the reason why in the letters there is contradictory statements. Statements of I love her, I miss her, I love her, over and over again. When he was with Mr. Eggers stated all Robert kept talking about was how much he loved Rebecca Schaeffer. He kept directing his attention back to Rebecca Schaeffer. When he was there, according to Mr. Eggers, he was there to meet her only. He searched Robert Bardo. Robert Bardo didn't have any weapons. If he had met Rebecca Schaeffer there, he wasn't going to attack her or kill her. He was going to give her a teddy bear and some flowers because he loved her. But yet, I'll admit that he did engage in thoughts of intent to kill. That's obvious. But it isn't clear, and it isn't established by the evidence, that at the time he approached her apartment, at the time that he committed that act, that he had that intent to kill. We know from his letter that he didn't have that intent to kill, that intent to kill arose at the time he was rebuffed by Rebecca Schaeffer. Now that is the evidence, and I argue that this letter should be considered and is reliable. It's reliable because it's a declaration against his penal interest. It's foolhardy to argue that he's going to send a letter that's self-serving. There's nothing that's self-serving about a letter wherein he admits that he shot Rebecca Schaeffer and he admits that he intended to kill her at that point in time. There's nothing self-serving about that at all. And the last point I want to address was Ms. Clark indicated that the waiting and watching for that period of time between his ringing the bell and nothing happening is sufficient under the lying in wait cases. And I respectfully disagree wholeheartedly. The waiting and watching, as described by the lying in wait cases, states that it has to be for the specific purpose of having an opportune time to act and to take the victim by surprise. The letter clearly states that he was there ringing the buzzer only to meet her, to talk to her again, to give her the letter, to experience those feelings that he addressed early on in the letter, the feelings of delight and happiness at having met his idol. So we disagree with that position. And as far as Lynn Martha, I think I forgot to address that issue. The testimony of Lynn Martha does not establish that there was not a conversation. We brought out that at the preliminary hearing, her attention, she testified that her attention prior to the shot was directed elsewhere. She had no reason to be eavesdropping or trying to listen as to what was going on. She was engaged in other activity, listening to her phone messages, feeding her cat, and whatnot. And it wasn't until the explosion of the shot occurred that her attention was totally focused on that event. She even admitted that at the preliminary hearing, and even here I believe she admitted that she's not saying there wasn't a conversation, she's just saying that she didn't hear it. And as far as the period of time between the shot and the hearing, I believe the buzzer, she said at the preliminary hearing, I believe she verified that here at the trial, that it seemed like a second. It seemed like a very short period of time. And we know that she is reflecting back and extrapolating. In any event, it doesn't prove that there wasn't any conversation at all. It doesn't prove that. It certainly doesn't prove that beyond a reasonable doubt, not to that standard. That's all I know.
With respect to Ms. Marta, I think what she indicated is that to some extent she was focused on Rebecca Schaeffer as she made her progress down the hallway because she intended to make contact with her. She also indicated that it required no effort to hear what was going on in that hallway, and I don't care what anyone says about her desire to listen, her efforts to listen, or what she actually paid attention to, because the conversation described by this defendant could not have been ignored. It was a shouted argument through a closed door that occurred over a period of time that had to draw her attention whether she would have wanted it to or not. And that is what refutes the viability of his statement. There is a big difference, Your Honor, between conclusionary speculations and reasonable and logical inferences to be drawn from the evidence. If we were not permitted to draw reasonable and logical inferences from the evidence, then there would be no such thing as cases that are tried and won on circumstantial evidence. The question is really which interpretation of the evidence is the more reasonable one. And in this case, Your Honor, we have many logical conclusions and inferences that we can draw from the evidence, as I pointed out. The conclusions that counsel would like the court to draw make no sense. He is telling us, first of all, in contravention to the law, that we are not allowed to pick and choose our way through a defendant's statement and that we are bound by the exculpatory statements that are contained in his statement. That is not the case, and it has not been the case for quite some time. There is no such law of adoption. We are allowed to pick and choose our way through a statement made by a defendant because we must. No one can possibly logically assert that this defendant does not have a motive to lie. And to assert that the statement made by this defendant to Mr. Cleves is not self-serving simply ignores the realities of the world. When you look at it, Your Honor, there's only two real defenses. I didn't do it, or I didn't mean to. When you're caught red-handed, as he was, what is he left with? I didn't mean to. When he thinks about what he is being charged with, and by the time this letter was written in 1991, he has had plenty of time to do so, he knows that what he must refute is premeditation. What he must refute is concealment of purpose. And so he concocts a story that could not rationally be accepted by any critical thinking person to say that I abandoned all my intent and in a rash impulse fired the fatal shot. It makes no sense. It has no logic to it, and it is totally in contravention to the entire bulk of the evidence that has been presented. And although it's true that initially the defendant did love Rebecca Schaeffer and did not intend to kill her in 1987, those emotions changed, and they changed to murderous hatred by the time he confronted her in 1989.
Anything further?
Nothing further, Your Honor.
All right. I've spent some time on this case, and in analysis, Mr. Galindo, I disagree with you in many respects. Number one, it is not necessary under the law of this state for a person to be found guilty of first-degree murder by lying in wait, or for the special circumstance of lying in wait to be true for the defendant to premeditate upon anything. The law is very clear, as stated in the case of People versus Webster, which was decided by the Supreme Court September 9th of this year. On page 10879 of the opinion as reported in the Daily Journal, it says, nor was there instructional error on the issue of lying in wait. The trial court correctly instructed that murder by means of lying in wait requires only a wanton and reckless intent to inflict injury likely to cause death. That is a statement that that is required for a lying in wait special, not the special circumstance, but rather the degree. All that is required is implied malice. Implied malice is not consistent with premeditation. Premeditation requires careful thought to the intent to kill, and then after having decided to, killing. So the issue becomes, in part, whether or not the defendant, even under the most favorable evidence to the defense, can be said not to have been there with malice aforethought. That's the threshold issue that we have to achieve before we decide whether or not he was lying in wait, in addition to all the physical evidence that is relevant to that particular issue. I think there's no question in my mind that a man who confronts a young lady in her apartment with a loaded weapon, which he's taken the pains to fully load, according to his letter, is there with malice aforethought, particularly once he has already formed an intent to kill. And the letter to Arlene, his sister, is not just a fleeting thought about killing. It expresses, in my opinion, a firm intention to kill. The phrases about having decided on a plan of action that will end everything and that will cause her to hate him doesn't talk about a fleeting, vacillating intent to kill, but a firm intent to kill. The intent to kill not only is firm in that letter, but apparently the defendant was so solid with this intent that when confronted by a statement that his niece had made to her mother about putting Rebecca to sleep, his response was something like, "I think she got it right." No denial. His plan to go there with a gun. I'm sorry, I don't buy this idea of carrying a gun around with him to prevent a robbery. I've lived in this town too long, and I know what can be done to prevent a robbery. You don't go into certain neighborhoods at certain times of day. On the other hand, here you have a man that is carrying a gun in a relatively crime-free neighborhood. If you eliminate drugs in the middle of the morning. The circumstances under which he went to the door at the time that immediately preceded the killing rather clearly amount to malice aforethought, even on an implied malice theory. When you consider his previous expressed intent to kill, his taking the gun and going to a situation like that immediately, according to his letter, after he had been rejected by her. And I think we've both been in this business long enough to know that the single most frequent cause of killing, aside perhaps from financial gain, is rejection. And according to his letter, he was rejected by her at the end of the first visit. He had been rejected by her at the studio, in phone calls, through intermediaries. I don't think we're talking about here a man who is, as he expresses in his letter, somebody who's merely going back to give a letter that he forgot to give her. The intent to kill that's required for the special circumstance is only that intent to kill that occurs at the time of the killing. I can see no reasonable doubt, even under the defendant's letter that does not create any reasonable doubt, if I were to take that as gospel, that he intended to kill. He has a .357 Magnum containing not only ammunition that's powerfully loaded, but ammunition that is hollow point, that he himself purchased, that he didn't come upon accidentally, being fully aware of the potentialities of this ammunition, as evidenced by the fact that he traded his brother for some weaker ammunition. Shoots a person in the heart. Clear intent to kill. And the special circumstance says the defendant intentionally killed the victim while lying in wait. No question this is an intentional killing under the evidence I've heard thus far. There's no question in my mind that he had at least implied malice when he was waiting for her to come to the door. The issue remains whether or not there is, or there are, those circumstances that the cases have held to be lying in wait. We have here a man who buzzes, rings the buzzer, waits for a lady to come to the door. She comes. He is now in a position of advantage. He is taking her by surprise. This has all the indicia of a lying-in-wait killing. And I would refer both of you to the case of People versus Ward. The Ward case is on all fours with this case. In that case, as you know, a man was hired by a bookie to rough up someone who apparently owed him money. The man sent his girlfriend to the door, waited for the victim to answer the door, and then immediately stabbed him. In this case, the only difference I see is the lack of an intermediary. The defendant himself rang the door and waited, and obviously concealed his purpose. For if he had stood there with the gun at the ready, I'm sure that Ms. Schaeffer would have gone back into her apartment and screamed. You're asking Mr. Galindo to find a reasonable doubt based on a letter. That letter, if it had been written immediately after the arrest, immediately after the crime, if I knew anything about the defendant's relationship with Mr. Cleves, was it? It undoubtedly would have much more weight than it has now. However, the circumstances of the letter are, if the date on the letter is correct, that it was written in March 26, 1991, it was written not only after the preliminary hearing, but after the 995 motion. The defendant was fully aware of the theory of the case, what circumstances the people were depending upon in order to secure for him the alternative of either the death penalty or life without possibility of parole. And I would submit to you, Mr. Galindo, that the most effective lie is the lie that includes a great number of verifiable, factual material. The material in this letter, the detailed statement by the defendant to Mr. Cleaves, and I don't know who Mr. Cleaves is, about all the people that he met and asked about Rebecca Schaeffer, to me, weakens the letter considerably. It's almost like these things are inserted into the letter to give the letter credibility. There is no doubt in my mind that the defendant knew precisely where the victim lived. We had testimony from a witness who is credible, who may even feel himself subject to criticism for giving out her address, that he not only gave an accurate address, but an accurate apartment number to the defendant. The defendant then, armed with this information, and you could argue all you want that he may have lost it, he went to the right neighborhood, he went to the right street, he was able to zero in on the right house. No doubt in my mind whatsoever that he knew exactly where she lived. Exactly. Yet he's asking people on the street, do you know this lady? Have you seen her around? One reasonable inference, and I don't at all consider this necessary to any conclusion that I may reach, but one reasonable inference is that he wants to find out about her habits. When does she leave for work? It is possible that he had, at that time, a plan to ambush her as she came out of the apartment. I don't know that, and I'm not so concluding. But I'm merely stating it in response to your argument that he's asking people where she lives. He knew where she lived. This conduct is even more consistent with him trying to find out what her habits are, what she does, in order to surprise her, than it is trying to find out where she lived. Somehow, like a honing pigeon, he zeroed in on the right apartment house, even asked very early in the game, this gentleman who is not here, was, I believe it came in through the testimony of Miss Kennedy, is this an apartment house or a house? Why would he ask that? A, he has an apartment number, perhaps he wants to be sure. But this, again, I agree with you, is a lot of speculation. But it is the most reasonable conclusion I can draw, although not the only reasonable conclusion. The point is that we have activity consistent with lying in wait long before the killing. Then we have this period of the killing where she comes to the door. I don't know whether she saw him and recognized him and said, well, what is this gentleman here for again, to herself, and I'll get rid of him. Although I find it unlikely that once, if she had recognized him, that she would say, after having told him, don't come back, and then she would answer the door again, going so far as to open the door. But again, let's deal with the hard facts. And the hard facts are that Marta, Ms. Marta, said very clearly from this stand that she paralleled the victim's walk to the front door. And just as she had heard the last step of the victim, she heard the blast. Now, if I'm in error in any way, please enlighten me, but that's what my notes indicate, and that's what I clearly remember asking. I also asked her myself, how long a period of time elapsed between the last step and the shot? And she said, a split second or a second. We are not talking about the kind of time interval that would be required if the kind of conversation had occurred that your defendant claims occurred in the letter. This letter being written after the preliminary hearing, after he'd heard what the evidence was against him, and after knowing that there can be no doubt that he's the killer, being written after the argument on the motion for 995, which was an argument based on the special circumstances, is not enough in my mind to raise a reasonable doubt. Let me refer to an antique case that neither side has cited, but I'm sure both sides are aware. People versus Thomas in 41 Cal 2nd 470. It's very old. It's 1953. 1953. However, I have a very clear memory of this crime occurring. I was in college when it occurred. And the reason I remember it is that I had just finished working within the last 2 years as a fry cook in a hot dog stand very close to where this occurred. This is an instance where a man saw a woman that he wanted to shoot at sitting at a diner. He drove past the diner, went into an alley, immediately took a rifle out of his car, shot at her, claiming to want to shoot a cup of coffee out of her hand. The bullet entered her ear and killed her. In the Thomas case, the Supreme Court, and this was an opinion, I believe, written by Justice Traynor. No, that's the concurring opinion. States the duration of the waiting, watching, and concealment necessary to constitute lying in wait cannot be arbitrarily fixed in units of time, just as the time necessary for the ordinary, willful, deliberate, and premeditated killing cannot be so fixed. When you read that language and the facts of the Thomas case, together with the facts of the Ward case, which are almost on all fours here, putting that together with the inferences I've drawn from the testimony, at this stage of the proceedings, based on this evidence, where the only thing that casts doubt on the defendant's intentions at the time he shot the victim are his belated, self-serving letter. And I'm concluding it's self-serving only with respect to what he said occurred to that door, at that door. I'm not picking and choosing. Again, had this letter been written immediately after the arrest, immediately after the crime, and if I knew something about his motivation in writing to Mr. Cleaves, my conclusion with respect to the value of this letter would be different. I'm not saying that I would find there's a reasonable doubt. It would have to be totally reweighed in the light of all the other evidence. But from what I see here, this is a slim reed upon which to hang a reasonable doubt, considering the fact that we have clear evidence that immediately upon her inferentially opening the door, because we know it was open, right at the end of her last step, the single shot that killed Rebecca Schaeffer rang out. I can only conclude at this stage of the proceedings that the defendant intended to kill based on his previously formed intent, based on his rejection, apparently, by Rebecca Schaeffer. If it occurred on that same day, and counsel are correct that it does, if the case hung on whether or not he made that first visit, I would certainly have a reasonable doubt, but it does not. hang on that. I can see no alternative based on the case law and on the facts of this case, but to deny your motion.
Well, I respectfully disagree with many of the court's conclusions, but I understand the court's reasoning. I would only indicate that we do disagree with the court's interpretation or of what is required as far as a mental state, but we don't need to get into that further at this point in time. Also,
The Thomas case back in 53 also says that the only mental state required for lying in wait is implied malice, and I realize that express malice is required for the special circumstance, and I'm not disputing that. But what that clearly says is that premeditation and deliberation upon the killing are not required for implied malice. And I'm not making a finding at all, because it's totally unnecessary, as to whether there was premeditation and deliberation at all. I'm merely finding at this point that the evidence does not present me with a reasonable doubt as to whether or not he lay in wait, as lying in wait has been defined in the California courts for almost 40 years. And there are other cases that I could cite, but I think these are right to the point. But the People versus Madison, for example, 4 Cal 3rd, makes the statement that the only mental state required for any of the means killings, which at that time were poison, lying in wait, and torture, is implied malice. Now, there is a line of cases that I'm sure you're aware of, People versus Wiley and Steger, which clearly state, 17 and 19 Cal 3rd respectively, which very clearly state that in a torture murder, it is necessary to willfully deliberate and premeditate the torture, not the killing, very clearly.
I'm aware of those cases.
Okay.
I've been doing this long enough to know that I don't believe I would be successful in changing your mind. I do disagree that the Ward case is
You might if you have something new, Mr. Galindo. But if it's a rethinking of what we've already said, I think you're right.
That's fine. We'll submit it at this time, Your Honor.
All right. Okay, you have a short witness. Let's take a 10-minute break for conference.
Longest JOA ever. Oh my God. Beat a dead horse much?
First and last name for the record.
My name is Calvin N. McShan, M-C-S-H-A-N.
Thank you.
Mr. McCann, would you state your occupation, please?
I'm employed by Los Angeles County as a defense investigator for the Public Defender's Office.
And your past experience?
I was a Los Angeles police officer for 14 years and a private investigations and security director for probably 10 years.
Are you the investigator in this case?
Yes, sir.
As a part of your investigation into this matter, did you have occasion to travel to Tucson, Arizona?
Yes, sir, I did.
And when you did that, did you have an opportunity to speak to an Officer John Norton?
Yes, sir.
Do you recall when you had that discussion with him?
On July 12th of 1990.
Did you compile an investigation report concerning your meeting with Officer Norton?
Yes, sir.
And for the record, I have provided counsel with a copy of that report. When you first approached Mr. Norton, did you identify yourself?
Yes, sir, I did.
And did you tell them the reason that you were attempting to interview him?
Yes, sir, I did. I first spoke with his supervisor.
Who was the supervisor?
I don't recall. It was some sergeant. This interview was conducted at the Tucson Police Department headquarters.
Did you identify yourself as being an investigator for the Public Defender's Office on this case?
Yes, sir, I did.
And what was the focus of your interview with Mr. Norton?
My primary focus was to determine what was Officer Norton's opinion of Mr. Bardo when he had the initial contact at the Interstate 10 and Congress Avenue. What was his initial reaction and assessment of his emotional condition at the time that he came up on the scene?
And did you explain the purpose and focus of your interview to Officer Norton?
Yes, sir.
Did Officer Norton indicate to you the information that he had received from a citizen concerning the activities of Robert Bardo?
Yes, sir. I asked him how did he come about receiving the call or the information regarding Mr. Bardo's presence.
And what did he say?
He stated a citizen had held him down. He was patrolling in a, what we call here, L unit, a one-man, something like a beat wagon, a van, a beat wagon. And this citizen had held him down and told him that there was a man that acted like he was mentally disabled up on the freeway, jumping in front of automobiles or attempting to jump in front of automobiles.
When?
Just a moment. I think I misheard a word. The citizen had hailed him down? H-A-I-L-E-D?
Waved,
okay.
Yeah.
I heard held. I'm
Okay.
sorry. Just want to clarify that.
Little
Right.
Texas accent, Your Honor.
Okay. No, it's all right.
When Officer Norton first approached Mr. Bardo and made his observations of Mr. Bardo, did Officer Norton tell you whether or not he had formed any opinions as to the condition of Mr. Bardo?
Yes, sir.
And what did he say?
He told me as he approached Mr. Bardo, which was at this point was on the on-ramp, the eastbound on-ramp of the Interstate 10 exit at Congress. So his first impression was, you have a mental problem? And Mr. Bardo kind of shrugged, looked down at his feet, and Officer Norton said, "What's your problem?" And Mr. Bardo stated to him,
Actually, none of this is impeaching, Your Honor. I'm assuming that all of this hearsay from Officer Norton is coming in to impeach as a prior inconsistent statement. So far, I haven't heard it.
Actually, it does. We're bringing this out for prior
We maybe get into it. We'll see what develops.
Did Officer Norton indicate to you whether or not he formed the opinion that Mr. Bardo appeared either oriented or disoriented when he first made the observation?
"Yes, sir."
And what did he say?
He stated that he asked him, well, what's your problem? What are you trying to do? And Mr. Bardo stated, "I'm trying to commit suicide by jumping in front of a car."
But did Officer Norton tell you that he, Robert Bardo, appeared to be disoriented and upset?
"Yes, sir."
Did he make that statement to you?
He did.
After speaking to Robert Bardo, did Officer Norton indicate to you whether or not he had in fact called for a mental health team unit?
Yes, sir. He referred to it as a MAC unit.
Did he indicate what the initials MAC, M-A-C, stood for?
I asked him, and he did not give me an explanation of the A, but the M was for mental, and I still wasn't sure. In fact, I called him back from Los Angeles, and I could not speak to him. But I asked him why did he call a MAX unit, because first of all, I didn't understand what it was. I didn't understand what a MAC unit was. We didn't refer to it here in Los Angeles then. He says, because I had a mental patient on my hand. I had a fellow with mental problems.
Did he make that statement to you?
That is correct.
So he told you that he ordered the MAC unit because he felt he had a mental patient on his hands.
Yes, sir.
Now, did Officer Norton indicate to you whether or not he had made any observations of the conduct of Mr. Bardo as he was making his observations. And specifically, I'm referring to his actions concerning how he spoke, his lips, things of that nature.
Yes, he stated to me that he appeared to be disorientated. He had somewhat of a disheveled appearance, as if he had probably slept in his clothing for a couple of days. His hair was uncombed. He admitted to the officer that he was attempting to commit suicide, taken with his observations along with the statements that Mr. Bardo made to him. It was his conclusion that he had a person with a mental problem.
Thank you. I have nothing further.
Mr. McShann, did you tape record this conversation, sir?
No, ma'am.
So when I take it, you indicate to us throughout this statement what the statements were of Officer Norton. These are your writings or your representations as to what he said. Is that correct?
To the best of my knowledge and as accurate as I could be.
It is not a transcription. It's not a transcript of a tape.
There was no tape.
Right. Did you ever give him a copy of this report and allow him to review it and perhaps correct what he thought were misimpressions you may have created in it?
He has never seen the completed report.
Did you ever offer him that opportunity?
The type report wasn't completed in Tucson.
I see, but after you did complete it, sometime after you got back here in Los Angeles, did you offer him the opportunity to review and correct it if he wanted to?
No.
Did you ever call him to inform him of what representations you were about to make concerning the statements he supposedly made to you?
No.
And when we have here statement by you that Officer Norton supposedly said that the defendant appeared disoriented and upset, did you ever tell him that that's how you were going to characterize his statement?
At the time of the interview, the points regarding the mental condition, I reviewed it with him on 2 or 3 different occasions. As a matter of fact, I asked him what happened when the MAC unit arrived. And he told me that the MAC, the mental health unit, never arrived because the dispatcher informed him that they were not on duty as of yet.
But the motion to strike is non-responsive, Your Honor. I'm asking you, sir, with
All right, I'll grant the motion.
Thank you. I'm asking you, sir, with respect to the words disoriented and upset, they do not appear in your report to be a direct quote. They're not at least encased in quotes. Is this your characterization of what he said?
Yes, he may very well have said nut or crazy, but I used that characterization.
So these are your words, sir. These are your impressions of what Officer Norton said to you.
Some are, and some are in quotes, which I specifically was specific quotes.
And when did you write down these specific quotes?
At the moment that I was interviewing him.
Did you show them to him to make sure that you got them correct?
Probably didn't show him, but I reviewed it with him verbally.
When you say you reviewed them with him verbally, are you telling us that you read it back to him and got his affirmance?
The specific wording are areas that I was concerned about, but not in entirety. But if he stated to me that he felt he had a mental problem, and he asked him, "Do you have a mental problem?" I reviewed that with him a couple of times. Now you stated that you said yes, that he had a mental problem, or this person, he felt that Mr. Bardo had a mental problem.
So in essence, what we have in this report is your recap, your summary of what was said to you in your words. Is that correct?
Not everything. Some words are specific in quotes, and I quoted them there in my report as quote.
And now I'm asking you again, sir, after you typed up this report and specifically put down quotes that you attribute to Officer Norton, did you give him the opportunity to review it and perhaps correct it if it was an untrue representation of what, in his mind, of what he felt was said in the interview?
And again, the answer is no.
Do you recall telling Officer Norton that the only reason this case was going to trial was because the prosecution was seeking the death penalty?
Pardon me?
Do you recall telling Officer Norton that the only reason this case was going to trial was because the people were seeking the death penalty?
No, I didn't tell him that. That's not Why would I tell him something like that?
Do you recall creating the impression with Officer Norton at any time that the purpose of your interview was to gather evidence for presentation at the penalty phase?
No, I did not present. I don't know what his impression might have been, but I'm there to investigate a case for our defense.
I understand that, sir, but you understand that in a death penalty case there are two phases? I'm sure you know that.
Clearly.
Okay. There's guilt phase and there's penalty phase. On occasion, are you not sent out to go and gather evidence for presentation on behalf of the defendant at the penalty phase?
It could very well be used for the fact phase as well. I go out before the trial commences, and quite often, sometime even before the preliminary hearing. So it can be used for, that's up for the attorney's decision to use what you're going to use it for. It's not my decision. I mean, I'm not practicing law, I'm investigating a case.
Well, when you're sent out, sir, aren't you given instructions to look for a specific type of evidence or given some idea as to what would be the purpose of the interviews you're being asked to conduct?
That is correct. Like, it was a focus of my attention on Mr. Norton's interview regarding the mental state or his impression or opinion of the mental condition of Mr. Bardo and his first impression on his first meeting.
So you were out to gather evidence that other people would characterize the defendant as crazy?
His mental condition, whatever.
I have nothing further.
Just so I understand the testimony correctly, Mr. McShannon, you were taking down notes at the time of your interview,
That is correct, Counsel.
and you did verbally verify the statements that you had written down with Officer Norton.
That is correct.
Okay. And you're certain as to his impression, at least when you were discussing it with him on that day, his impression was that he had a mental patient or a mental case on his hands, correct?
That is correct, and he further substantiated his opinion by requesting a mental health unit to come to the scene to assist him with Mr. Bardo.
Thank you. I have nothing further.
Anything further? Ms. Clark?
Thank you, Your Honor. No, nothing further.
All right.
May this witness be excused?
Yes, you may. No objection, Ms. Clark?
No objection.
All right, you may be excused.
Thank you, Your Honor.
John, as we had indicated earlier,
Yes.
we were going to have only this witness for today.
Right, and so we'll be in recess then. Let me take a look at, as far as I can, Friday's calendar so I can set a reasonable time. Let's give a valiant try for 10 a.m. Looks very reasonable and a distinct possibility. In recess until that time on this case.
I'm a detective for the Los Angeles Police Department. I'm the homicide supervisor at Wilshire Division, LAPD.
You're the homicides supervisor.
Yes.
And were you working in that capacity on July 18th, 1989?
Yes.
Can you relate your training and experience as far as it relates to
The powerful Mach 5.
writing of police reports
And when there's a chance of adventure and there's... You can come by.
I've been writing police reports since 1970.
Doing some shopping, huh?
I've been writing police reports related to homicide investigations basically since 1977. I've been working homicide off and on, mostly on, since 1977. I've written probably thousands of reports related to homicides.
In reference to the writing of police reports in regards to homicide investigations, would it be fair to state that you have been trained to take detailed and accurate notes as far as interview of witnesses?
Yes.
Did you, on July 18th, 1989, or a short time thereafter, have an opportunity to interview a witness by the name of Mr. Oscar Moreno?
Yes.
Francis Ford Coppola.
Did you cause a report to be written concerning your interview?
Yes.
What the
Prior to your testifying or coming to court today, did you have an opportunity to review your police report in reference to the interview of Mr. Moreno?
Yes.
Prior to your testifying,
That was my
there,
tie.
did you have an opportunity to discuss that matter with the prosecutor, Ms. Clark?
TV,
Very briefly, yes.
gotta get it together. Why is there papers?
Showing you.
That's right, Cynthia. Court, if it's not already underway, maybe getting underway any minute. I just want to background our viewers and you, of course, on what has transpired in the past few days. There's no court on Thursday. On Tuesday, the prosecution rested. They wrapped up their case, putting on some of the people closest in life to Rebecca Schaeffer, her former boyfriend, her former best friend, her former talent agent. And then the prosecution wrapped up his case there. The defense put on their first witness on Wednesday. He was a detective for the Los Angeles County Public Defender's Office, or an investigator, I should say, not a detective for that office, who actually traveled to Tucson to talk to the police there, who actually arrested Robert John Bardo. Also on Wednesday, the defense made a motion to dismiss parts of the prosecution's case, and the part they wanted to dismiss was the whole issue, Cynthia, of lying in wait. The idea that Robert John Bardo somehow concealed himself, set a trap for Rebecca Schaeffer, in which she fell to her death. The judge, after hearing motions from the prosecution and from the defense on whether or not to dismiss that lying in wait part of the construction of the first-degree murder charge, decided to forget it. This trial is going to go ahead without that dismissal, so the lying in wait will be included. And the importance of this, of course, is if you're not lying in wait, it's hard to argue it was a premeditated crime. If it's not premeditated, it's not first-degree murder, and so the penalties are significantly reduced should a guilty verdict come down. Right now, the defense is starting with their second witness, we expect is coming up to the stand any minute now. And also later on today, if it is admitted, and we believe it will be a videotape of the actual Tucson interrogation by the Tucson Police Department of Robert John Bardo on the day he was arrested back in July '89.
As far as you could determine, were his statements to you voluntary?
Yes.
Right. According to authorities here in Los Angeles, police authorities here in L.A. and also in Tucson, Robert John Bardo committed this crime. That is, according to the state, he did this crime, and he went back to Tucson, hopped on a bus, went back to Tucson, and was said to have been found dodging high-speeding cars or on the highway, dodging cars speeding quickly, I should say, on the highway. And when he was come upon by police, actually, I think a motorist flagged down a policeman and said, perhaps you guys should look at this. There's a guy up on Highway 10 who's jumping in front of cars. He may not have a full deck. In other words, he might not be all together there. The police, so following up on this, did indeed find him out there on the freeway, back and forth, darting in and out of cars. And according to the testimony that we've heard, Cynthia, they asked him, "What are you doing? Are you crazy out there?" And Robert John Bardo replied that he was trying to kill himself, trying to commit suicide by dodging in and out of these cars. He was subsequently arrested by Tucson authorities.
I believe 125 in the suites around.
Did he tell you when the first time... Let me back up. Did he tell you when the first time was that he had seen Mr. Robert Bardo?
Yes.
Did he tell you that the first
we have heard that has been reported, and that version has yet to come out in this case. We expect the prosecution to get into that, the defense, I'm sorry, to get into that whole issue as part of their case, if they so choose, of course. There are so many issues regarding the arrest of Mr. Bardo, and also his extradition to Los Angeles. The whole issue of whether or not he was fairly extradited. According to the prosecution, he was. According to the defense, he was illegally snatched out of the hands of Tucson authorities and returned to Los Angeles County to stand trial, and that whole issue of whether or not his extradition was illegal or not, and whether he should even be on trial at this point, is, as I understand it, going to be heard by an appeals court out here in California. So there are many issues swirling around this, not the least of which, as you mentioned, is the actual arrest back in July of '89.
Did he tell you his location when he first heard what he believed to be a shot?
Yes.
And where was that?
He was on the west side of Sweetser Avenue, he had just parked a car. and was
Sure.
walking
The
back
defense has not
north
put in a plea at all.
towards
The
Beverly
state
Boulevard.
filed the plea, and it's a simple, straight, not
he indicate
guilty.
whether or not
I
he
talked to a
was,
defense attorney, public defender Stephen Galindo, and he talked to me a
close
little
to
bit
the
about
alley?
the whole reason that happened, and it goes back to the extradition. The defense not wanting to put in their own plea on the grounds that this trial shouldn't be happening in the first place. But he told me their
Related to you that he
defense
had heard
isn't going to be a not
shot?
guilty by reason of insanity. It is the diminished
stated he
capacity
heard
or
one
diminished
shot or
actuality, as you said,
One shot.
and we expect to hear a lot of psychiatric testimony from psychiatric experts
Did he tell
to
you
say
whether or not
essentially that
he
Mr.
heard
Bardo was
anything
not of a
else
didn't have the mental
immediately
capacity
after
to
the shot?
premeditate this crime. And
What
of
did he
course,
say?
if the crime's not premeditated,
Did he hear a woman
then
scream?
the possible life in prison could possibly
Did
be
he say he
significantly
heard-
reduced.
A singular scream, or did he hear
But I forgot what it
multiple screams?
was.
If you recall.
Well, I don't recall that I ever asked that specific question. To me, a woman's scream was
Said he was illegally
self-descriptive.
Did he indicate to you then, after hearing a single shot and after hearing a woman scream, whether or not he had observed anyone running from the area?
Yes.
And what did he say in that regard?
He told me that after he heard that, he turned around and he observed a white male running north on the opposite side of Sweetser Avenue, would be the east side of Sweetser Avenue.
Did he say whether or not he made any further observations of this individual?
He described him for me. He said he was 5 feet 7 inches tall or taller, appeared to be about 25 years old. He had curly brown hair. He was wearing a yellow shirt with a collar, a pair of Levi's, and some sandal-type shoes. He told me that when he reached the alley just south of Beverly Boulevard, the man stopped and loitered at the corner of a building there for probably 30 seconds to a minute. It appeared that he was hiding. After a minute or so, the man ran east in the alley.
When he described the man and characterized it as loitering, did he tell you exactly what conduct the individual was engaged in?
He described it as he thought the man was attempting to hide.
Did he indicate whether or not the man was standing upright or laying under some bushes perhaps, or under a car or anything like that?
Standing upright.
And standing upright against a wall?
Well, there's a corner of a building right there at the mouth of the alley, so one could stand on the east side of that building, of that corner, and be somewhat hidden from Sweetser Avenue.
You say somewhat. What do you mean by that?
Well, depending on how far behind the building he got, obviously.
And he was, from your vantage point, I take it, in examining that area, he would be exposed to view depending on one's vantage point, correct?
Yes.
So the man did not indicate that he was totally hidden under a car or anything like that?
No.
Did he indicate whether or not, after this 30-second to 1 minute period of time, whether or not he observed the man to engage in any other type of conduct?
He told me that after the man loitered for 30 seconds to a minute, he ran east in the alley, yes.
Oh, that's right. I couldn't remember
Did he
what
indicate
it was.
whether or not the man was carrying anything?
Yes.
And what was that?
He said the man was...
Vague, at what point in time?
I'll withdraw. Did you strike that? Did he ever make any statements to you that he did not want to speak to you or participate in this investigation?
No.
Did he ever indicate to you that he did not want to get involved in this case at all?
No.
And your notes do not reflect any statements to that effect. Is that true?
Yes.
I have nothing further on it.
Sir, how long have you been a detective?
Since 1977.
How many cases have you handled approximately?
Countless thousands.
In the course of that time, sir, over the thousands of cases that you've handled, have you ever had occasion to have to interview witnesses who were illegal immigrants?
Many times.
And have you had any special problems in handling such witnesses?
I have found them to be generally reluctant to be interviewed. There is a general reluctance to be involved with the police, or for that matter, any part of the judicial system.
For fear of deportation?
That's correct.
So in order to get their statement, did you have to, on many occasions, reassure them that their involvement with you and giving you information would not involve their deportation?
I've done that many times, yes.
And after having done so, were you then able to elicit more information from them?
Yes.
In this particular case, did you take the time to try and assure Mr. Moreno that his involvement in this case, or truthful telling of all that he knew, would not hurt his chances of remaining in the United States?
No, because I didn't really even know his immigration status. I didn't know if he was a citizen or not.
You didn't ask him?
No.
And on that particular occasion, when you had the interview with him, was that the day of the homicide?
Yes.
Would it be unfair to characterize that particular day as being one of considerable activity?
I think hectic's a good word.
So you did not have time to sit with someone whom you could tell was not an American citizen to reassure them that they were not facing deportation possibilities before you took the statement?
Well, it wasn't only a matter of time, it just wasn't an issue at that point, period.
You were just making a general cursory overview of the people present to get an idea of what they saw. This is cross.
It is cross. I was under the impression you were getting favorable answers, but if you want to be technical, I'll allow it. Go ahead.
I'm sorry, would you repeat the
You
question?
never know when the witness may turn, Your Honor.
I always talk to my witnesses beforehand when I'm a lawyer, which hasn't been for a while. Go
He was a
ahead.
defense witness, Your Honor.
Absolutely. Had
I'm
he
sorry,
asked
would you
me
repeat the question?
on cross, I would have allowed it. But go ahead.
At that particular time when you interviewed Mr. Moreno, were you basically taking a quick statement from everyone to get an idea of who saw what before you did more in-depth interviews?
Yes.
So that was neither the time nor the place to sit down and start explaining to him the immigration consequences or lack thereof in getting involved in this case?
I think that would have been very inappropriate.
I have nothing further.
Yes.
Correct.
Officer, you indicated that you did not reassure him about the legal immigrant status and effect of that status on his statements to you because it wasn't an issue, correct?
Yes.
Isn't it true he did not need any reassuring at the time you interviewed him?
Well, objection, that calls for
That does
speculation.
call for speculation as to what Mr. Moreno subjectively needed.
Did he, I thought I understood your testimony to be that he was cooperative with you.
He appeared cooperative, yes.
Raccoon emoji.
Did you make a notation at all, or did you indicate, strike that, did you make a notation at all in your report of his statement to you that he appeared to be reluctant or appeared to be cautious about giving you statements or testimony of any kind?
No.
And was your mental state at the time that Mr. Moreno was being less than truthful with you?
I had no way of determining that at that time.
Okay, but clearly, based on your experience and your thousands of interviews with witnesses, have you not had occasion to interview witnesses that you felt were being elusive or hiding something from you?
Well, I think we're talking about two different things here. It's not uncommon in my experience to interview somebody a second or a third or a fourth time, and during that subsequent interview, learn that, in fact, they saw more than they originally reported, or or are able to identify the suspect when originally they said they were doubtful or had seen the car when originally they said they hadn't, or something like that. But as far as was that occurring with Mr. Marino at that time, I had absolutely no way of telling.
Well, did you have, but my question was, based on your experience, you have had the occasion to interview witnesses whom you thought, or at the time at least, had some indication they were being elusive, less than truthful. Isn't that true?
Yes.
Okay. On this occasion, did you have any reason at all to believe, based on your past experience, that Mr. Marino was being elusive or less than truthful?
I had no way of telling again.
But I'm asking if you were able to tell. Did you have any reason, as far as you could tell, based on your experience, to believe that he was being elusive with you?
Yeah, an objection has been asked and answered. The witness is refusing to speculate based on insufficient data.
I think that the objection asked and answers has considerably less weight on cross-examination, especially when we're trying to clarify matters of rule.
As I recall, Mr. Marino was the first person I interviewed, so I had absolutely no criteria. I had no way of knowing what he had seen and how valid it was.
That's not my question, sir. My question is, was there any indication by Mr. Marino that you could observe based on your past experience to indicate to you that he was being less than truthful, was being elusive? That's my question.
Well, I suppose if I'm going to be forced to answer that question, I would have to say no.
Thank you.
In other words, from what you were able to tell, as to what Mr. Moreno did tell you, he was being truthful.
Correct.
You could not tell, however, whether he was telling you all that he knew.
Exactly.
I have nothing further.
Anything further, Mr. Galindo?
No, Your Honor.
May this witness be excused?
Objection. No, objection.
Thank you. May be excused, sir. Thank you.
He's creepy looking. I wouldn't answer the door for him, that's for sure.
And it would appear to me that the only thing that is relevant is the footage that has to do with Mr. Bardo. I will look at the whole thing, but if there's anything else...
Okay, this video is an hour and a half. So, if we go to 10, we'll have to stop in the middle of it. But we're behind on the other trial, so we could just go to the other trial now, because we're playing catch-up anyways. What do you guys want to do? I gotta buy Travis a cervical pill, and there's some that are 35, some that are 25, some that are 12. I feel like the more expensive ones would be the better ones, but I don't know. Do you want to keep going with this for another half an hour? Or go to Walsh? Or are you guys going to make me make an executive decision? Okay. That was going to be judicial. That was going to be my judicial decision anyway. Okay. It's supposed to redirect. You know how that goes, so I'll see you over there in a few minutes. I do want to go to the other one. Okay, I'll see you over there in a few minutes.